Well, my name's Bo Oliver, and for those of you in the room, I think you all know that my son is Brooks Oliver, who teaches ceramics. Whoever is watching this on video might not know him, but I'm a Vanderbilt law grad. I practiced law for about 35 years. I did not focus on art representation, but I've done a lot of contract claims along the way. Last year, Alicia Eggers, I think is her name, asked me to speak to her class on some City of Denton art installation contract, and it was so narrow and biased, and I thought, everybody needs a broader perspective on contract law to really understand what's going on. So that's kind of the genesis of how this thing came to be. I'm not a professional speaker. I'm going to basically work from an outline and read it along with you, but I am going to highlight some points. I'm going to try to accomplish two things today. One is to give you a 1-hour primer on contract law, kind of like you would learn the essence in your first year of law school and contracts, to understand contracts generally. And then secondly, and probably more important, to give you a specific heads up on what contract provisions you need to have a heads up on and pay attention to, because they're the ones that are going to impact your lives at certain points. And, no doubt a lot of the stuff I'm going to talk about today is stuff you already heard, you already know, what a general contract is, And as my old secretary used to say, well, it's TFO, that's effing obvious, But a lot of it's not. A lot of it you really hadn't thought about before. And so I really hope that that's what you get to latch onto today, because you might think this is blowing you a bunch of smoke, but this might be the most financially rewarding 1-hour class you've ever taken, because it might save you thousands of dollars in your life. We're not just going to talk about art contracts today. We're not just talking about gallery representation agreements or that. We're talking about employment agreements. We're talking about your purchase contract for your car. We're talking about the lease for your apartment. We're talking about mortgage documents. It's stuff that's going to impact the rest of your lives. You're big people now. Nobody's ever told you this stuff probably before, but we're going to cover a lot of it today. So appreciate that it's some good subject matter, even though you're not a lawyer and you might think I'm full of effing stuff, whatever. Feel free to ask questions as you go along. If I don't make myself clear on points, there is going to be a time for some questions at the end. I might say on certain questions that we'll get there in a second. Generally, I'm going to cover some real broad points about contracts, and then we're going to go into narrower points and talk about specific provisions in contracts. So, next, why written contracts? Well, oral contracts are really hard to confirm the specifics because you don't necessarily have a clear meeting of the minds. You might think you're saying one thing, but the other side might be thinking something else, and you don't have all of the terms of the contract in one place. I'm going to cover a lot of different legal terms today, and just so you understand what they are, course of performance disputes are, hey, we might have this oral arrangement, and we all kind of do things a certain way repeatedly, and that's a course of performance, but that might not be what your real contract agreement says, and so you get into disputes because things might change over time. And number 4 is the key, they're messy and they're difficult to enforce. Written contracts are the key, and that's why when you go to a bank and you go to a car dealership, everybody wants it in writing. The key is it identifies the parties, it sets forth the consideration given by each party, that is what each side gives. You do this and I pay you that. It's enforceable by both parties. Enforceable means you can go to a court. If you breach an agreement, somebody can take you to court. If they breach the agreement where they've represented something to you, you can take them to court. The goals of the written contract are to have clarity and being reasonable to both parties. You're going to get a whole lot of one-sided agreements thrown in your face in life. And some of them you're not going to be able to negotiate. They're just going to say, no, this is our standard form and you can't do it. But on things like gallery representation agreements, they're going to start out really one-sided, and you just need to add some language that balances them. And there's another concept called mutuality. it'll be a one-sided agreement. The gallery has all these rights and you basically have nothing unless you add a provision that says, hey, this cuts both ways. It can be mutually onerous to both of you, but as long as it's cutting both ways, it's a little bit more fair. So they're typically biased, but you're going to try to balance them out. Written contracts typically require written changes. We'll cover that. There's a thing called the statute of frauds, which is a legal statute that says certain contracts have to be in writing. And the key ones that are anything involving real estate. You can't have an oral lease agreement for your property. You can't have an oral house sale contract. And the other thing is performance lasting more than a year. If the subject matter of the contract is going to last more than a year, it has to be in writing in order for it to be enforceable. Next. All contracts, well, I don't care if they're short, they're a one-pager or not, if you do your job, they should identify the basic relationship between the parties and who the parties are. They're going to cover a term, a certain period of time. And the term is impacted by termination provisions because there's going to be a lot, like your lease says, it's for 1 year unless renewed. And those are or terminated earlier because you've given notice you're going to terminate. And that's what termination provisions are. Realize that the term, the time of the contract, and the time of performance are different. One is the agreement lasts a full year. The time of performance is on November 1st, I will do X. On December 1, I will do Y. So obviously, agreements set out the basis of performance. One side agrees to do one thing, the other side agrees to the other. Performance includes payment. I will hammer on payment because you guys want to get paid for your work. But there are a bunch of other applicable terms, and don't ignore the boilerplate provisions that people stick at the bottom of the contract because they can really mess you up if you're not aware of them. They might be just fine, but don't just assume they're fine. Make sure you read them and make sure that you agree to everything as it is. I'm going to harp on defined terms because defined terms are important and you need to make sure that they're limited to the proper scope. And by defined terms, it'll say, the John Thurman Art Gallery, Perrin's quote, gallery, and that's going to be fine, and in you. But if they say is contracting with you, Bo Oliver, and all your brothers, sisters, and other people, and they try to make that a defined term as under Bo, that's not good. It's just you individually. So you got to make sure that everything is defined in scope right. Next. A big part of this subject matter is how you negotiate a contract. And really, I just want to tell you, give yourself some time. You're going to enter into agreements that, like an art gallery representation, might last for a year or two. Do it. Give yourself some time. Ask for their forms and make sure you finalize the agreement before you begin performance. So don't deliver your artwork and then be arguing about some provisions in the contract. Wait until you get your deal done and then go act on it. Be reasonable and fair, and then you establish trust. Now, this is just a common sense point. Y'all are going to be entering into agreements the rest of your life, and the contract forms might be biased, but what you're trying to do is enter into a relationship with somebody. Be fair and reasonable to both parties, and say it to them. I'm being fair and reasonable to you. I expect the same thing, and that's how a lot of times you'll get them to bend and add some provisions that will allow you to have your interests a little bit better protected. If you don't understand an agreement, ask what it means or get help, because once it's signed, it's hard to unwind. All right, the goals, protect your interests. Well, the best way to do that is to have clarity, and we'll get into that because you want to have some detail as far as what your expectations are, and then this balance. I talked before about mutuality. It's a balance measure. It's okay to have something that's very almost draconian in the agreement if you both have to live by it. It's one thing for them to say, if you breach the agreement, they can sue you and collect their attorney's fees. That's a one-sided agreement. Make it mutual. hey, if either party breaches the agreement, the prevailing party gets their attorney's fees. That's a mutual provision. It exposes them just as it exposes you, and that's what you want to have. Next. All right. This is like the basic order of what most contracts have in provisions. And not every contract has to have every one of these, but you're going to see them. And so in a minute, I'm going to go through all of these kind of in order. But here they are. The agreement's entered into on a specific date. The date should usually be at the very top of the contract. If it's not, it's going to be down at the signature line. And it's going to be between these two defined parties. Whereas or recitals, and a lot of times people like set up contracts and they say, whereas we intend to have this mutual relationship, blah, 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 and therefore we agree as follows. A lot of it doesn't even make any difference that they're in there unless they're incorporated into the rest of the contract, and it'll say if it's incorporated. We talked before, it's going to have a term when the contract starts, when it extends, whether there's renewal provisions, performance payment, risk of loss. This is a point I'm going to hammer with you guys because this is where you get into disputes. Who bears what expense when things go south? And there's going to be other covenants and representations. And what the hell is a covenant or representation? It's just something that you say to the other side that you make a representation and it has to be accurate. For example, a gallery officer is going to say, well, I have authority to enter into this agreement on behalf of the company. Well, that's a representation. You're going to likely make representations that your artwork does not infringe upon somebody else's artwork, that you haven't copied it, and you're going to have to live up to it. But those representations are going to be in there. Other governing terms, that's a lot of this boilerplate stuff, but I'm going to explain what a lot of that stuff means so you kind of know from hereafter, and then you have signatures at the end. Next. So the introduction, to be the very beginning of the contract. It's entered into on this date between the different parties. We talked a moment ago about defined terms. That's where you usually are going to have the John Thurman Art Gallery on 21st Street, hereafter gallery, and when you ever use gallery, you don't have to repeat that whole long sentence. Make sure the names are correctly stated. You're going to have entities we'll get into in number 5. Entities are a big thing. You're going to want to get advice on this later on. But generally, you can represent yourself as an individual, meaning it's just in your name, or an individual doing business as a trade name, whether it's Lady Gaga or we used to own a car wash, and it was Uptown Properties, Inc., doing business as Uptown Car Wash. It's a different name than the formal entity, but that's why you have a defined term in the beginning, because then you don't even need to use Uptown Properties, Uptown Car Wash, just Car Wash, or whatever you use. And you can also do business as a partnership. Partnerships, you partner with somebody else, you both have mutual liability for everything, period. They can sue one or both of you, and they don't necessarily go to one or the other first. Or you have things that have limited liability, and those are LLCs, limited liability companies, or corporations. Limited liability companies or corporations are ones that say, provided you follow the rules of doing business as a limited liability company, you have limited liability so that the amount of money that you've invested in it is all you can lose. You can't lose more. They can't come back and say, okay, you do business as a gallery, there's some unintended consequence, somebody, I don't know what the circumstance would be, but there's an accident that involves a worker, it's beyond the amount of insurance your gallery has. They can't come after you individually if you've set up yourself in a corporation. That's what limited liability is. It's just, you're only exposed to the extent you have assets in the company, and the company has insurance, and insurance is a risk of loss provision. All right, we're moving. Next. If I can get my next. All right, the term of the agreement. Oops, did I skip one? I'm sorry, the recitals, we already covered them. They're no value unless they're incorporated. Make sure they're accurate though. Next. The term of the agreement. This is important, not so much because of the beginning and end and anticipated end date, but what the real end date might be because of termination provisions. So pay attention about termination provisions because they are conditions. A condition when you get to a contract means that it's something that has to be done in order for the next step to go forward. If you don't follow the provision, you don't follow the condition, you're out of luck. So for example, your lease on your apartment might say it's for 1 year, but you have to give 30 or 60 days notice of your intent to terminate, or it rolls month to month. So what that kind of means is, all right, let's assume it's a January 1 to January 1. You have a 30-day termination obligation or notice obligation. So by December of the next year, after the 11th month, you have to give notice of your intent to renew. If you wait until December 10th, theoretically, you're on the line for January rent. It then becomes a 13-month lease. So that's why you have to pay attention to these things. If a notice obligation says you have to give notice, you have to give notice. It's a condition. There are other provisions like employment contracts, whether you can be terminated for cause, you did something bad, or not for cause, which would be at the discretion of the other party. And you're going to have a lot of agreements where you have the ability to terminate on 30 days notice. You have a gallery representation agreement. You like them a little bit, but you've been approached by somebody else with a much better deal. Hey, if you have a deal where you can just give 60 days notice and you're out, you have 60 days and you're out. It doesn't have to be for a specific reason. You have discretion to terminate. Notice requirements typically are in the general terms at the end of the contract. They might be up in the term provisions, but they might be buried down in the boilerplate language. And that's why I'm telling you, you always got to read that boilerplate language because it might be where your notice provisions are. Survival of termination, there are certain obligations that extend beyond the end of the formal contract. Your contract might be involving art for a year, and then it's over, but the gallery doesn't get sued for infringement until the 15th month, but you've represented that you don't infringe, and your obligations to defend them on infringement claims are going to extend beyond that 1 year term. Does that make sense? So they live on, and that's what a covenant, you have covenants to indemnify people that, in the event that I've infringed on something, I'm going to hold you harmless, meaning I'm going to defend the gallery and, on something like that. That's something that goes beyond the termination of the basic term of the agreement. Here it is again. Pay attention to renewal notice conditions. There's a couple of these points I'm going to hit about 5 times. All right, next. Performance obligations. Clearly the who, what, and when. Who is responsible to do what? You need to add the detail, to add what each party is going to do. And describe it in as generally specific provisions as possible. I know that might be considered an oxymoron, but you just saying the gallery is going to represent artists is too generic. What the heck does that mean? You want to say they're going to do certain things for you. They're going to show your artwork in the store. They're going to dedicate however many shelves to you. They're going to show artwork in exhibitions. If that gallery goes and shows at, a City of Denton fair, they're going to take your art with them and show if that's what your agreement is. They will advertise on your behalf. These are important provisions. So it's not just that they're going to represent you, they're going to do something. And you might even say they're going to send out advertising on your behalf, in the amount or approximate amount of $1,000 a month. So that you get a commitment from them that they're binding themselves to do a certain amount of performance for you, and in turn, that's why you're willing to go with them, because they're really going to support you. You have to provide the work, you have to replace sold inventory with additional work, etc. Describe the when. When is work or performance to be done? The biggest issue here, I think, is delivery of your work and the return of your work. When you're going to get your work back, because I think James has heard, I represented Rob Lugo on a case, and there was a situation where the art gallery that helped him with a summer internship, basically he did all this work. They wanted to be paid some additional money, but they had all of his work and they wouldn't deliver it to him. And so he didn't even have anything to sell to pay them. But you should have a provision that says, you're going to return my work no matter what. And I'm the owner of the work. And we'll cover that later. But payment is a separate obligation. And if you don't pay, they're entitled to sue you for it and get interest and attorney's fees and everything else. As far as when payment is going to be made, that's something you guys want to make clear. They're not just going to pay you after they sell your piece and then they drag it out and it's 90 days, it's 180 days. No, you want to say you're going to pay me in the next 15 days. You're going to need to pay me in the next 30 days. Whatever you agree to, I'm just saying, describe the when. Next. I hammered on some of this already. Delivery obligations. When do you supply your art? You're not going to supply the art until you have an agreement. When are you going to get it back? You have to state when you're going to get the art returned to you. So whenever you terminate the agreement, you should have the right to go pick up your artwork. Another big performance issue you guys have with artwork is installation and de-installation. Another Penn State professor I represented, Shannon Goff, showed some artwork in I guess a Georgia gallery. And it became a problem because she delivered the art to them. It had certain installation instructions with it. But then when they tore it down at the end, they messed it up. They didn't repack it right and they destroyed her artwork. And then they kind of said to her, well, you didn't have, these de-installation instructions. And it's like, well, BS. Once it's in your control, you should have the obligation to take care of it. Something else I'll cover. But just realize that that's an issue. You want to state who's going to do what, who's going to provide installation instructions, de-installation instructions. If your work is, sensitive, it's easily breakable. If they have the obligation to repack it, they should repack it. They should insure it with UPS and send it back to you. But you want to put that into the contracts. And that's where shipping goes. Shipping, UPS, you know how to pack your own stuff, or you will learn how to pack it. This is something that Brooks deals with all the time because he's got to send his stuff up to Minnesota or wherever he's showing it, up in Montana at Archie Bray. You want it to get there right. But these things all involve an allocation of costs between the parties. That's what performance obligations are. Not only do you do things, but then when you incur expenses, how are you going to allocate them between the parties? So allocation of costs is a big deal. Man, you have so many questions. It's just kind of scary. All right, payment obligations. Here's what we really want to talk about as artists. How are you going to get paid? Well, you can get paid a specific sum. You can get paid a percentage of sales. A lot of times, I know Brooks sells, through a gallery, and they get 50% or they get 35%. All right, that's fine. You have to state what that is, and you're not going to get paid unless some condition happens, unless they sell the art and they collect money for it. But you also want to make sure the calculations are clear. This is where a lot of people don't really think about it. Is it a gross sale or is it a net sale? If the gallery is saying, I'm going to represent you and I'm going to incur profit or I'm going to incur expenses, I'm going to have workers, help sell the product. Well, you need to get paid on gross sales, and they don't get to deduct from your 500 sales price the fact that there was a worker in the store for 4 hours that day and you have to pay the worker. Make sure you have the calculations of what you're going to get paid. It's going to be the gross price of the good. All right, when you will be paid, we've talked about that. On a specific date, get the date in writing. How you will be paid, it's also important. You don't necessarily want to just take their regular check. You'd rather have a certified check or a money order, or better yet, just an electronic funds transfer, whether that's Venmo or it's something else. Just get the cash in good funds. That's the key. So if there's any question that these people are, fly by night, that they're not going to stay in business, you just don't want to take their regular check if you can agree to do it. On the front end, have it put in the contract. Next. All right, this is very important. Risk of loss. All right, this is the rewarding class, because hopefully you're going to spot issues in your situations that can potentially save you thousands of dollars because you don't get into a legal dispute. They save you a lot of money. And it involves risk of loss. What happens when things go south? It's all fine and good when everything's going forward, but it's when Rob Lugo doesn't get his artwork back, or Shannon Goff doesn't, her pieces are destroyed by the gallery. And then you got the issue, and then you call Uncle Bo, and he comes in and tries to get you out of Dutch. All right, so make clear who has the financial responsibility for the art at each time. And it should be in light of possession and control. I could reread that 3 times, but that is usually the key. Usually, the artist is responsible until delivery into the other party's possession. So you're responsible for the artwork when you make it. You have the artwork. You're responsible while you pack it. You're responsible for UPS shipping it right. And if you have to insure it through UPS, insure it. But once it gets to them, once they take over dominion and control, it's in their possession, they should be responsible. So you put that in the contract. So once it's physically delivered, then they take over, which is the second part. And control is important. And then, going back to what we talked about before, is the gallery or the artist responsible for installation and de-installation? It might be that even though you've delivered the art to some place, you have to go into that place and then install it, and then arguably you're in control of that artwork while you're installing it, if it's a big, giant aerial piece or whatever. But then once you've done the installation, you're done. Until de-installation, then who's going to do that? All right, protection exists in the form of insurance. I feel like a Geico commercial here. You can have insuring agreements. You're going to have them with a little UPS and FedEx. Who's responsible for what? What's the amount that you're going to have? But let me talk about general liability insurance. I think my thing got... No, it's on the next slide. Who pays for what insurance and then what amount? But going back to general liability insurance is what you have that protects people that come to your business, and or a gallery is going to have liability, general liability insurance. They have a fire, it's going to insure them for the value of the art. And then there's a question of who pays for that. But there can also be a dispute because there's incidental losses and whether they are covered. And so you're going to have to get into that. So who pays for insurance and what amount? Generally, the gallery, the people that are representing you, are going to pay for insurance on their premises, which should include your artwork. Does that make sense? But you may need to make sure you understand that they are insuring your artwork while it's in their possession. And be aware of deductibles. This is another issue we had in the Lugo case. The lady said, okay, in her representations in an email, wasn't part of a contract, in her email, oh, your artworks could be fully insured. What the hell does fully insured mean? Is it the price that they're agreeing to sell it for? Is it a $10,000 Lugo super sonic vase that's just awesome? Or is it the $5,000 that he's going to get because he's agreed to sell it on commission? These are the issues. And the lady says, well, no, I have this deductible amount of $5,000 and you basically don't get squat. It's like, no, that's not the way it's going to work, because the gallery, makes the decision on whether they want to fully insure everything or whether they want to have a deductible. No different than your car insurance. Are you going to be responsible for the first $1,000 in a collision case or not? it doesn't make any difference. You want your work to be fully insured for the full anticipated sales value. Because if it gets damaged while it's in a gallery, you're out. I mean, yeah, you spent all that time in your work, but you otherwise, if you only get paid for the amount that the base amount, then you don't have the right, or the potential to have more profit if you got the artwork back and sold it by yourself. You didn't have that commission on the next sale, and you can make twice as much. So you want to make sure you're fully insured. Hey, do you have a question?
Yeah, I just have a question about that that's sort of related. So I'm a painter. I donated a piece to a charity auction, and it sold for like $4,000. So I tried to deduct that from my taxes, and my accountant was like, you can only deduct basically the cost of the canvas and the paint. That because it's, I could have said.
I'm not a tax lawyer, but I would tend to think that you have the right to deduct the value of your art before the value of the made art, and it's not just your supplies.
Right. So
but it would be the $5,000 in my hypothetical. It wouldn't be $10,000, or it wouldn't be $4,000 because they sold it for $4,000, but you made it for $2,000 because they included a whole lot of your time and effort. I think my understanding would be you should be able to deduct $2,000. And that's still covered by your tax bracket. So it's not like you're going to get the full $2,000 credit. Excuse me for interrupting.
No, but like in this instance, you in a legal contract, you and the gallery can just decide, even though a piece is not sold yet, this is the value of it. And
for insurance purposes. For insurance purposes.
Okay.
When they say it's going to be fully insured, if their representative picks it up, drops it, how much are you going to get paid? And I'm saying for purposes of that insurance or protection, you should get the sales price. You want to make it the gross. What gallery, you and I agree that the amount of insurance you're going to carry or the liability will be that you obligate yourselves to pay me in the event that the art is damaged while in your possession equals the price that you have placed it for sale. Okay. And they're going to say, well, it's $10,000. I was going to really sell for $8,000. I don't care. For insurance purposes, they ought to have a contract with their insurance company that says it's $10,000. Okay. Or if there's another provision, agree to the provision. If it's in middle ground, just think about, this is issue spotting, and make an agreement so you have a common understanding. Yes?
Okay. Just so to clarify, if it's damaged in their possession, you're saying that we should advocate that we are reimbursed for 100% of the supposed sales price?
Yes.
Okay.
That's what you want to target. Okay. You might not get it, but that's the issue that you want to have in your agreement. Now, this is the kind of stuff I'm saying, this will protect you. If you have a $4,000 painting right there, I might have saved you $2,000. It's a good class. All right, and be aware of deductibles because they're out there and somebody's going to argue about them to you, but it's not your responsibility. You can always insure your own work. You can always say, my work is worth $4,000, whether it's anyplace else, and if it's damaged, it's no different than like pro sports guys, Dak Prescott. He insures himself from injury. If he doesn't get his big new contract, he's still got $50 million of insurance this year if he suffers a career-threatening injury. All right, ideally gross value. Try to always make the value as high as it can because that's in your interest, Again, TFO, I think. All right, covenants and representations. Both parties typically represent certain things. You'll see a actual title in a lot of documents that just say covenants and representations. And usually it's somebody has authority to act, the signator has authority to sign on behalf of the gallery. You typically are going to have to make a representation regarding infringement so that the gallery says, well, I'm not going to get sued because your artwork, James, is the same as Susan's. Susan's suing me. Well, then you're going to have this defense or indemnification obligation. We'll get there. Exclusivity. Here's one of those legal terms. What's that mean? It means they can only represent you and nobody else in a certain situation. You might not get exclusivity. I'm just saying be aware of it. You, Brooks, might want to go to a certain gallery and say, look, I'll place my stuff with you, but I'm going to be your only ceramics artist. You can have painters, you can have sculptors, you can have anything else, but I'm going to be your ceramics guy, or I don't want to sign up with you. That's exclusivity, so just be aware of it.
And I've run into galleries on the flip side want you, so that they're not competing with other galleries in town, that oftentimes they'll do zip code, state, county.
Excellent point.
Geographic exclusivity. They'll come at you if you're looking at gallery representation.
Yeah, they're going to say, hey, the quid pro quo, meaning what's good for you is good for me. Yes, I'll represent you exclusively, but I'm going to be your only gallery representation in Denton, Texas, or in Denton County. A lot of times scope provisions are geographical. They're going to say in a 4-county area or within the state of Texas, whatever. But that's exactly right. And again, that's mutuality. Okay, we're exclusive for this term in this area. Authority, I covered that. Ownership of art. Always be smart and make this clear. When I'm talking ownership of art, you own the art. If it's in their possession, they're responsible to take care of it. But you always want to have a provision that says you own that art. You own what I create. And if you don't get that representation, at least you're going to know you're arguing about it, and you're going to do it in advance. When Lugo, she kind of said, well, I gave you the facilities to make this art, and so I own it. No. If he had a provision that said, I always own the art, I might have to pay you money for this internship. I might have to reimburse you your expenses. Hey, that's fine. But I own the art, because that way I can get it back and I can sell it to pay. But always have a provision that says you own your art at all times.
This comes up with certain residencies. So you get really excited about a residency, but then you're not really, you're excited about the opportunity, and then you're not really looking at the fine print, and it comes up, oh, well, everything you make while you're there, they own, or...
And in certain circumstances, that's warranted. Texas Instruments hires people to do very specific things and develop products. Yeah, they're giving you the information, the past processes. They're probably giving you a bunch of proprietary data of their own with which to improve, and they should own it. They should be the owner of the patent at the end of the deal, but they're going to have that in the contract. And so again, this is issue spotting. Whenever you get a contract, try to add a provision that says you always own the art. Okay? Next. How are we doing on time? We're going good. All right, breach of performance obligations. This is the argument about who gets to do what when the other side doesn't perform. The key, big word, is being able to point to a specific provision that's been breached. That's why you want to have clarity. They didn't return your art. They didn't pay you in time. They didn't advertise on your behalf. They're going to sue you. You gave me defective art. You said that when I sold a piece that you would pick it up and deliver it to the people. You picked it up and then you delivered them another piece. You snuck something in or something. Those are the kind of things that the more clarity you have, you don't have to paper up a contract and make it 15 pages long, but just realize that you want to have what provisions you need in there to describe in clarity what an event of default is when somebody has done something wrong. And there's usually a notice obligation that says, if I've screwed up, you have to give me 10 days notice to cure it. I didn't mean to. I didn't want to get into a problem. I was supposed to pay in 10 days. Hey, I forgot for whatever reason. Give me notice. There's a 10-day condition in there. Strictly comply with notice requirements. And then after 10 more days, because it says in 10 days, You have 10 days to cure, and if you don't cure, I can sue you. That's what that is. You give notice. Notice is a specific provision. How you give it, U.S. mail or hand delivery. Who you give it to, you hand deliver it to the gallery representative. Whatever it is, in a specified manner. So realize that's it. Did you have a question? I'm sorry.
A quick question, and I understand it depends on the provision, but like, let's say advertising. So they agreed to advertise, but let's say their advertising is kind of crappy. Like they put up flyers, but don't do any online, posting. So how specific would you get as far as, and then
that's up to you, your art style,
right.
what you expect, what the marketplace demands,
All right.
I mean,
But you should clarify that.
if you can.
Okay.
They have a great Facebook or Instagram following. So add that. I mean, you can't control, this is what I'm talking about. You can't make it a 15, 20-page contract and everything. You're going to do everything, and everything's in little fine print. But get the basics done. Whatever you can, however much. I'm spotting issues for you today. You're asking a perfect question. You spotted the issue. How do I control it? You get what you can, but it's an issue. So you want to add whatever you can to protect your interests.
Because like the difference between like they did a crappy job versus defaulting on the contract, I guess.
Well, that's what a performance obligation is, and I'll get to that in a little bit in a global sense in a minute.
Okay, cool.
Just realize outside the contract, under Texas law, the Civil Practice and Remedies Code, you usually have to give 30 days notice of a breach of contract to get your attorney's fees in court, unless your contract says it, that the prevailing party gets attorney's fees. But you can have a contract that does not say the prevailing party gets attorney's fees, and you can still get attorney's fees if you give 30 days notice. Just a heads up. All right, failure of the party to cure the default. That's you had a default, you complied with the notice provision, they failed to cure, and then that provides the opportunity of enforcement. That's why the notice requirement is a condition. You can't sue them until you give them that notice. So live by your own conditions. Next. All right. The boilerplate language at the end of the contract. Other sample governing terms and what those legal principles mean. All right. This is legal, but we're going to say, when you see that contract that has all these damn little, provisions in there, generally what they mean. Release provisions, what claims can and cannot be asserted. Usually a release comes up in settlement, meaning that, all right, we've settled our disputes and we release each other from any and all other claims, period. Both sides were done. But there are also times where you can actually say, you can't sue me for my art advertising being inadequate. I'm going to try to do my best. And we'll get to reasonable care in a minute. So the release or the promise not to bring certain claims, just beware of the scope. What are you agreeing to do? Don't make it overly broad. But if you're in a settlement, you do want it as broad as you can be. Any and all claims of every type or any kind, blah, blah, blah. Other than for breach of the payment obligations in your settlement agreement. I probably didn't make that clear. If you have a settlement agreement, it usually says, we're going to sign a document, we're going to release all claims, and I will pay you X amount of dollars. And you're going to say, that's fine. We release everything other than this new obligation to pay me the settlement amount. Does that make sense? Generally limit to the subject matter of your agreement. Describe what you're settling. Next, indemnification. That is, what claims do each party agree to defend? This is big in infringement. The gallery says you have an obligation to indemnify me and hold me harmless from claims by others that your art infringes on their work. And we covered this already. I think it's common sense. But realize indemnification means that you have to defend the gallery. The gallery says, oh, James sued me for, $50,000 for infringement. Well, you have to hire a lawyer and you have to defend that claim. or you need to pay that party who's claiming infringement some amount of money to make that thing go away. That's what that indemnity obligation is. James sent me a waiver of release from University of North Texas, the multimedia waiver and release, and it had a paragraph that says, I release and agree to indemnify, hold harmless the university and all of its agents, employees, licensee, and assigns, the released entities, a defined term, from any and all claims that I may have now or involved in invasion of privacy, right of publicity, copyright infringement, blah, blah, blah. And I struck it. I said, I'm not going to indemnify you for crap. I'm volunteering my time. I'm not going to create a financial obligation. So realize you strike the provisions that you don't want to have. And there's your damn agreement, James.
Thank you on behalf of the university.
Yeah, okay. The university. All right. That's what indemnification is. Next. Come, James. Come, babe. Waiver. Waiver is the known relinquishment of a known right. I mean, I know I have this right, and am I truly waiving my right to enforce it? The disputes typically come up when it's a repeat waiver. If payment is due 10 days after the gallery sells your piece of art, and they pay you 20 days after, and they pay you 20 days after, and then they pay you 30 days after, what you want to have is a provision that says repeat waiver provision that says just because I didn't assert my rights in the past, the first time you didn't pay in 10 days, that doesn't mean I waive my right to get paid in 10 days. Does that make sense? So you have a right. It's a known right to be paid within 10 days. You're not waiving it just because you didn't enforce it the first time around. Your landlord's going to be in the same boat. He has the right to throw you out of your apartment if you don't pay within a certain amount of time. But I guarantee you your lease says that if they accept payment on day 20 or 30, there might be a penalty for that, but it doesn't mean that the next time they don't enforce the right to be paid on the third day of the month that they've lost it forever. Related to release and notice is this concept here, number 3. You can have a waiver associated with a contracted agreement to act within a certain point. For example, the artist agrees to waive claims against the galleries for damaged artwork returned to your possession if you don't assert a claim within 30 days. There's a thing called a statute of limitations. How long do you have to bring a lawsuit under the state of Texas? Breach of contract, it's 4 years. Negligence can be, causes personal injury to you in an automobile accident, it's 2 years. Frauds, 4 years. Different provisions. That's what the law says, but you can contract for other provisions. And this is a reasonable thing for the gallery to say, hey, if I give you the work back and I've shipped it and it's in containers just because you didn't unpack it for 90 days, hey, don't make a claim later, or don't unpack it and then say, okay, when you damaged it, and then you're going to say, oh, no, it was the gallery. You delivered this back to me. Yeah. What you do is you allocate risk of loss between the two of you by saying you can have an agreement that says, if you don't make a claim within 30 days, you don't give me a notice, then it's gone. That's a matter of contract that supersedes statutory law. Statutory laws are the laws that are written in codes that the government passes and, the black letter law. All right. Does that make sense? Jurisdiction, venue, applicable law. This is not going to come up very often, but be aware of it. Jurisdiction is the courts that you have to bring a claim, and it's going to be, jurisdiction is state district court. Venue is within all the state district courts of the state of Texas. Venue is Denton County. It's the type of court, jurisdiction. The venue, the specific deal. It's either going to be in Denton County or it's going to be the Northern District of Texas if it's in the federal court. And applicable law. Applicable law is really what I want to talk about, because you're going to negotiate contracts with different people in different states. And if you can get Texas law to apply, it's always going to be to your benefit. You don't know what the laws are of the other states, but if you've taken Mr. Oliver's class, you know that generally you've heard what Texas law might be on a subject, and you're going to feel more comfortable with it. But the key to this is these provisions describe where you must file a claim. Shannon Goff, she's up in Pennsylvania, Penn State. She gives her art to the art gallery in Georgia. Well, whose law applies, Pennsylvania or Georgia? You know, in fact, they didn't even have a signed contract, so it wasn't clear. But what you want to have is your home court advantage. So whenever you can, make it, if you're negotiating with somebody in Oklahoma, make it so they have to sue in Texas courts. That means they have to come to you to sue you for something. In Lugo's case, you know, the gallery was in Massachusetts. You know, what was he going to do? He didn't know anybody in Massachusetts. If it wasn't for me saying, look, lady, I'm going to hire local counsel because I'm willing to take the hit for Rob's behalf, but you're not going to get away with this. So if I have to hire local counsel to shadow my work, and I'll do all the work, and all that person has to do is agree to sign it, I'll pay that hourly rate, but that's the only way I can get up to Massachusetts to help him, because I'm not licensed to practice law in Massachusetts. But realize if you have applicable law and you've decided that the jurisdiction of venue, if there's a breach of contract, it has to be filed in Texas, that would have made the gallery come to Texas. You might not get it. Issue spotting, just be aware. That's what the terms are. Applicable law controls the dispute. Yes?
If you don't specify, what does it default to? Or is it
The general rule is wherever the majority of the contacts that took place exist, or the type of obligation that was breached. Which is why when you have a payment provision, you want to say they're going to pay you in your account in Wells Fargo Bank in Denton, Texas. Which means that kind of, by default, cleverly brings them in that the payment obligation was to occur in Texas. They have to, you know, you can sue them in Texas. Even though they did all the representation up in, you know, North Dakota, I don't care where. If the payment obligations are going to pay you in Texas, then you get to sue for breach of that obligation in your home court. That's why you have lawyers and shit. Oh, I'm sorry. Is "and shit" appropriate for the video? All right. Here's the key again. Try to be in your backyard. Backyard courts, backyard Texas law if you can get it. All right. Next. Damages. Damages is a whole course in its own, but realize there's two basic types of damages. It's actual damages, and then there's incidental damages or resulting damages or whatever you want to call it. If a car wash operation, if we have a fire in the car wash, our equipment, our inventory, everything is damaged, that's an actual damage. Our profits from being out of business for the 6 months it takes to rebuild the place is not actual damage, it's incidental damage. It results from the actual damage. And it's not covered unless you say it's covered. So just realize that's the big difference on damages, the incidental damage. You know, I have a 3-month, $3,000 a month lease obligation. You have agreed to pay me, art gallery, within 30 days, which should allow me to pay my landlord, and if they don't pay, you get thrown out. That incidental damage, tough. That's not their responsibility, you know, unless you contract to cover all damages and incidental damages. And then when you have incidental damages, you usually have to state what they are: lost profits, lost rent. A rent house is my other example where my rent house, for somebody gets damaged in a storm, I don't get my lost rent while it's being rebuilt unless I've contracted with the insurance company for that. And insurance provisions that you guys have for your houses in the future, they'll have that in there. Statutory damages is a different concept because you have common law damages, which is the general principles that courts have enacted back and forth. Statutory rights are what the laws are that are enacted by the state that you live in or federal statutes or whatever. And they create special damages. That's a third, I said two, there's really three. It's actual, incidental, and special damages. Special damages are a special right, and they're usually in statutes to allow you to level the playing field. You might be dealing with some big company, but if they defraud you, they do a deceptive trade practice, you have the right to sue them for actual damages, and if you recover, you get 3 times your actual damages. That might be what the statute says. I'm using it as an example. The Texas Deceptive Trade Practice Act does say you get 3 times your actual damages over $1,000. So it just lets the little guy have some stroke dealing with the big guy. So that's what these statutory acts are about. Just realize they give you a special right to get damages from somebody. And they might include damages, costs, and attorney's fees, which takes me to the next page. Costs, you're hearing that word, what the hell does cost mean? It's costs in a legal contract are the cost of pursuing the legal remedies, such as a filing fee with the court. It costs you $400 to file a suit in Denton County. It costs you $50 to have the person served with process. Here's the lawsuit. You have to answer it with, specific time. It also includes expert witness fees. Some courts might be attorney's fees, but attorney's fees are usually separately. Even in the absence of a statutory claim, you can contract for attorney's fees. I said that before. Make it a mutual provision. Whoever prevails gets their attorney's fees, and that's what that key recommendation is. Levels the playing field. Next. All right, you're going to see successor and assign language. Who's bound by the contract? You're going to see it in there. Just realize successors and assigns are the people that follow the legal rights of the person you initially contract with. I make a contract with James Thurman Art Gallery, and my contract is for a year, and after 1 month, he gets bought out, and it becomes a different name. Well, you have a contract with the successor. That's the deal. Or if he has the right to assign the contract, meaning it says in there, the gallery has the right to assign this contract to its brother, gallery or something like that. If it says they have the right to assign contract, that means they can move the contract to somebody else. A lot of times, it'll come up in real estate deals, which is why I'm telling you about things that aren't just art. But I might do a contract to buy a piece of property, but I have the right to assign my purchase contract to one of my kids so that my daughter Claire can actually be the buyer when it comes time to close the deal. That's an assignment. It'll say I have the right to assign to my kids. I write that in the original contract. Even though I signed with the seller, we've contracted, I have the right to assign my contract to my daughter Claire. She can buy the contract, she can buy the house in her name, or the townhome, or the condo, whatever. That's assignment. Merger, it should be merger / entirety of agreement provisions. You're going to see these in a lot of contracts. It's going to say all oral representations are merged into our written agreement. So whatever we talked about, you can't rely on it. You can only rely on what's in the contract because everything else is merged into this agreement. So we're not going to have a dispute. But you said X. Yeah, we have, so realize when you see that merger clause at the end, that's what it means. Force majeure, if you ever heard that expression, it's just a blanket excuse that lets people out of performance. The gallery's going to represent you, but blah, 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 a tornado hits and it destroys everything. It's an act of God. And so, everything's off. And that's what that is. Performance standards. Here's what we were talking about. You're going to have deals that are reasonable. Certain things have to be done reasonably. I've done so many contracts where the one thing that I have put in the contract is the word reasonable in 10 different places. So they don't just get to do anything. They have to act reasonably. As a reasonably prudent person would do, you want to say a reasonable amount of quality of damage of art advertising. I'm not sure advertising's the best thing, but I want to contrast it with sole discretion, because sole discretion means that they can do whatever the hell they want. It's in their discretion. They decide how much they can do, what they do, when they can do it. But what you want is to have them that they're going to act reasonably in dealing with you. And there's going to be like some blanket terms someplace in the contract that says they just have a reasonable obligation. Your landlord has an obligation to maintain the roof and the HVAC system, heating, ventilation, air conditioning. They have to act reasonable in getting it fixed. You give them notice, hey, my AC's out. They have to act reasonable. They can't just sit there and say, oh, I'll get to it in September when you tell them in June. They have to get to it within a reasonable amount of time. You might not say 10 days. They just have to do something reasonable. And you can argue about it. But if it's clearly going to 30 or 60 days and you don't have air conditioning for 60 days, that's unreasonable. So you see what I'm saying? Reasonable care, there's going to be a performance standard, and having an obligation for them to do something reasonable is one thing. It creates an obligation to you for them to act reasonable versus sole discretion, they can do whatever they want. Now, discretion is okay in certain other actions. Both of you might agree we can terminate our agreement on 30 days' notice. Fine. That's sole discretion. Both of you have it. You're done. But that's it. Statute of limitations, we covered that. It's 4 years. If they breach an agreement for failure to pay, you can sit back and sue them 4 years later if you want, but you don't necessarily want to do that. I'm just telling you there is a legal provision that says you have to sue within a certain amount of time. Next. All right. Somebody told me at the last class that this was the most important thing I covered. Battle of forms. How the heck do I modify somebody else's contract? Somebody sticks a piece of paper in front of you, and what the hell do you do with it? How do you change it? All right, here are 3 key ways. The best approach is ask somebody for the agreement in Word format so you can change it, and you can do track changes. As you probably all know, you use Word all the time. That way you make it changes and it's in one document and you don't have a bunch of interlineations and handwritten edits and stuff. So that's the best way, because that means when you finally get to a signed contract, it's clean in presentation. Second approach, if there's something in a contract and you can live with just about everything, but there are certain things you just, I can't live with that, you need to do what I did with James's form, strike the words and initial them on the side. Or strike the words and put a little caret and add a few words. Put in your own words. And you'll see that a whole lot if you've bought a house. You'll make an offer, and they usually require it. You make an offer, and you use that initial offer form, whether it goes back 3 or 4 times, you'll have interlineations over once, twice, 3 times, whatever, that goes back and forth. People keep changing it, and there keeps initialing it, blah, blah, blah. And they do that because ultimately it tracks what your agreement was, and it doesn't matter anyways because you're going to actually have purchase contracts when you go to closing anyways, and those will be clean. But in any event, when you get the gallery's agreement that says X, Y, and Z, and you can live with most of it, but you want to change a few words, you want to add the word reasonable in 5 places, stick your little caret in there, make it and initial it on the side, because under a mutual agreement, they have to initial it also in order to become a final part of your agreement. You can't just change it for yourself and not bind them, because there'll be other language in the agreement that says, you can only have written changes to an agreement, which means that somebody has acknowledged it in writing that they're bound to it. Third approach, an addendum. Somebody can give you a damn contract that has all kinds of stuff that needs to be changed. And the easiest way to do it without trying to interlineate and change all kinds of stuff is simply to write an addendum. Do a 1-page sheet, addendum. The parties to this contract, use the other reference, hereby agree as follows. And so that's your preamble. We agree to the foregoing agreement is supplemented and amended pursuant to the addendum. And here's the key, to the extent there's any conflict, the terms of the addendum control. You have to have that second part. That eliminates the provisions that say, oh no, I get to rely on the former contract. Nope. you have your form contract, but our addendum is really going to cover the key terms. And to the extent that there's a conflict, our addendum is what controls. So you can put in additional provisions and just do them by number. Either write complete new provisions or reference the other ones. Paragraph 2B of the agreement is amended to read. Change the words to what you want. You can, and then the addendum, you can go back and forth on Word. You can get it cleaned up. But, but they're going to say, oh, this is a standard contract, and our lawyers don't want us to amend it. And I say, well, okay, but I'm not going to do that deal. I'm willing to do your deal with several specific changes, and here they are in the addendum. If you want to do business with me, here's how we're going to do it. So that's how you change somebody else's documents. You get the damn document in Word, and you exchange it back and forth. You handwrite your changes and initial them, or you do an addendum. Does that make sense? Next page, equally important. Written contracts typically require written amendments. It can only be amended in writing. And so, all right, how are you going to amend it? You can do a formal contract amendment. A lot of times the easier way to do it is simply by a letter that is exchanged, but has to be signed by both parties because that's what a written amendment is. So this letter will confirm our agreement to amend our contract dated last year as follows. You put in your provisions, you have a signature. Then after your signature, please confirm your agreement by signing the letter and return to my attention. And then once they've done that, they've accepted the change, now this is a new part of your contract. Does that make sense? Instead of doing some formal amendment, just write a damn letter to them, but get it confirmed in writing. Signatures. When we owned the car wash, we had a lot of employees that were not educated, just didn't understand a lot of this stuff. And it's like they'd ask me, what do I do with this? My landlord, so I said, give me a copy of your lease. They didn't have it. You're a big boy or a big girl from now on. Keep copies of your agreement. Keep a file someplace in the house. You just put your key documents in. I don't care if it's a warranty on your new air conditioner, if it's a copy of your lease, it's a copy of your purchase contract for your car, your lease for your car, whatever, your insurance, your personal life insurance, whatever. Have a file and keep copies of documents. All right? That's a TFO, but I swear it's amazing how many people don't always do it. Oh, I got that done. Here, you have the documents. Well, how are you going to enforce it? Well, I think that document says something. Well, where's your copy? Well, I'd have to get it from them. Well, they don't give it to you. You're kind of hosed. So be smart. And if I'm not mistaken, the next slide says questions. Oh, no. Couple extra issues. Work for hire. Disclaimer, this is not my area, but I'm just telling you, a heads up. Again, issue spotting. You can either be an independent contractor or an employee. You've heard these words before. An independent contractor does work for himself, even though it might be for your benefit. A plumber is an independent contractor. He's working for himself, and he's deciding his own hours when he shows up and what he's going to do and how he's going to do it. He's an independent contractor. He's not an employee. And you can be both. You can work for the gallery or you can be an independent contractor. If you control your own hours, your own workflow, you're usually an independent contractor. Independent contractors don't get benefits, but just realize you're either one or the other, and you want to go back to what I talked about before. Who owns the work? If you're an independent contractor, it's yours. That person really shouldn't have a claim on your work unless you're an employee and you're working for them, and then they've provided facilities and stuff. So make sure you own your work and that you will have it returned to your possession. I keep bringing that stuff up. Copyright, this is another class. If you have a certain type of work that can generally be described as something, even though you're an artist, you can get it copyrighted and you can have basically patent rights, infringement of copyright laws. But you have to have something that's really a common theme. But some artists have it and just realize it's out there. I used to work at 3 or 4 different three firms, giant firms, except for the last one, Kessler Collins. There's a woman there, Andrea Perez. She's great. She represents artists in Dallas, people, and does contracts with the Dallas Museum of Art or stuff. I've talked to her in the past. I said, can I put your name out there? She's agreed. In fact, she wants it because it's potential clients. But she's good. She's young. She's happening. Give her a call if you need legal representation. It's a good person to start with, just to say, I can do it or I can't do it, what's going to cost, blah, blah, blah. Here's what I recommend. So I always throw it in there.